An uptown bodega worker is out on bail now, but still facing murder charges after being attacked 10 days ago.
Yeah, now this dispute was over a woman's debit card being declined. Her boyfriend came in, he went behind the counter, and he attacked Jose Alba. Alba got up, grabbed a knife, and stabbed that boyfriend to death during the struggle. Big issue now, was this self-defense?
Yes, Peter Tilem is a criminal defense lawyer. He joins us now to give us his insight. Peter, thank you so much for being with us.
You're welcome. Good morning.
Good morning. People are just so curious about this case, obviously. But to you, Peter, what does this look like? Is it self-defense?
It does look like self-defense. You have to remember something, that when a person raises self-defense, the government has to prove beyond a reasonable doubt that it's not self-defense. And so the burden in this case, after watching that video, would be very, very hard to overcome for the prosecutor to prove that this was anything but self-defense.
Well, let's talk a little bit about the rule about when you can use deadly self-defense. Is it any different than, I mean, it's one thing to maybe shove somebody or push them, it's another thing to stab them. Is that nuance there talked about in the law?
It is, and it's an important nuance. You can use deadly physical force only when you believe that deadly physical force is about to be used on you. However, there are some exceptions to that, and one of them is to terminate a burglary, which this may be considered a burglary under the law. A burglary is not necessarily what we believe is breaking and entering into premises, but it's the entering into premises where you don't belong. In this case, the back of that store or the back of that counter where it's closed to the public with the intent to commit a crime therein. That's burglary. And so this person may have been acting to prevent a burglary. He also may have been acting to prevent a robbery, which is just the forcible stealing of property, which seems to be what was going on there.
Right. And Peter, have you seen any similar cases that can kind of establish a precedent here?
Well, of course, everyone is drawing parallels to the Bernie Goetz case, which is one of the preeminent self-defense cases and still is the law in New York on self-defense. There's a case, People versus Bernie Goetz. And everyone remembers that case who's old enough to remember it. That was a very different case, although if you remember, Bernie Goetz did beat the case on self-defense.
Well, let's talk about the defendant here, bodega worker Jose Alba. He was originally held on $250,000 bail. Now, we talk here so much about bail reform. What do you make of the bail being set that high when the Manhattan DA has been letting lower-level offenders out with almost no bail or very little?
I mean, this almost appears to be a war on law-abiding New Yorkers. Here's a man who's working 12, 13 hours a day, according to the reports I've read, and not making a lot of money, working in a bodega, literally just trying to go to work, no criminal record, doing what he has to do to support his family. And then all of a sudden, this person with a criminal record, a violent criminal record who served time in prison, comes in the back, attacks him, and the presumption of guilt goes out, the presumption of innocence goes out the window, and essentially this person is incarcerated on very high bail, even though nothing's been proven yet.
Right. And Peter, we know there are a lot of factors that have to be obviously evaluated and weighed, but how difficult is it to make a winning self-defense argument? Obviously, in this case, there's video evidence.
Right. So I think the video evidence is going to be very important in this case. Obviously, jurors love the ability to see with their own eyes what happened. Ultimately, lawyers on both sides are going to make arguments. You are correct that when there is the use of deadly physical force, there's a higher level that needs to be shown. There has to be a reasonable belief that the person believed deadly physical force was about to be used on them. But there's a lot of factors there. There's also a duty to retreat before you use deadly physical force. I think everyone would agree from that video that there was no opportunity to retreat with complete safety.
Yeah, that video tells a lot. So we'll talk a little bit more. You alluded to it earlier, the burden of proof for proving self-defense. Talk about who has the burden here.
Right, so it's very interesting because generally the prosecution has the burden of proving every element of every crime. However, when a defense is raised, in most cases, the burden then shifts to the defendant to prove by a preponderance of evidence, that's called an affirmative defense, that the offense applies, the defense applies, and that they should not be convicted. In this case, though, the burden never shifts back to the defense. In fact, it stays with the prosecution, and it is the burden on the prosecution at every step to prove beyond a reasonable doubt that self-defense did not apply in this case.
So, Peter, in your opinion, at the end of the day, what do you think is going to happen? You think self-defense is going to win?
I do not believe, listen, this person is entitled, Mr. Alba is entitled to testify before a grand jury. I do not believe there's any grand jury in New York that will indict him. My recommendation, if I was his attorney, I would put him into the grand jury. I'd let him testify about what happened. And I would tell the grand jury how he felt at that moment. And I think that he will not be indicted in this case.
Very interesting, very enlightening. New York criminal defense attorney Peter Tilem, we thank you for joining us this morning.
Thank you. Have a good day.